All right, this is Mark Kenney. I'm with Brent Kawakami, and then also Dugan Kelley from Kelley Clark. Dugan is our attorney. I've known him for probably 11 years or so. Does all our real estate transactions. Phenomenal guy, and he's a wealth of knowledge in many different areas. But today, in particular, we're going to talk about using 1031 exchanges, in particular into syndication. So, Dugan, thank you for joining us today.
Hey, thanks, Mark. Thanks, Brent, for having me. I'm excited to be able to share what I think is, frankly, one of the best and underutilized mechanisms for sponsors to get capital, right? So in an uncertain world about being able to raise either debt or private equity, what we're going to talk about today is exciting because 1031 people, they have to deploy their capital. There's no ifs, ands, or buts about it. They either are going to pay taxes on that money or they need to essentially reinvest back into the market. And so for years and years, many of the self-proclaimed gurus out there had said you cannot syndicate a multifamily acquisition and also include 1031 funds in that same transaction. I mean, it was like a complete bar. And I said, that's not true. I mean, the reality is that's not true. So thankfully, over the past few years, the lights have been starting to come on and people are becoming warm to the idea of being able to syndicate and also include alongside the syndication, this idea of 1031 funds. So this is why we've called this why multifamily syndicators and passive investors, these are people that need to redeploy their capital, should care about 1031 exchanges. What is a 1031 exchange? So many of you that are listening to this or watching this may not realize that it's a specific code of the IRS tax code that allows property owners to sell one or more of their properties and exchange those with one or more like-kind replacement properties. So this is a special part of the tax code, maybe one of the very few provisions of the tax code that actually people like. Right? So the vast majority of us don't like the tax code, but this is one section that everybody, especially investors and sponsors, should like because this allows you to defer the taxable gain on property that you've essentially sold. It enables you as the taxpayer, if you're the person selling that investment property, with little or no tax liability on the resulting gain. So basic bottom line, this helps investors because it continues an investment without adverse tax consequences. It allows you to leverage up into an apartment building, something that many of you that have 1031 funds probably thought there's no way, right? Because if the sale proceeds are not sufficient enough for me to get the loan myself, then you thought to yourself, probably I can't, there's no way that I can participate. So your mindset is focused in on smaller commercial properties when hopefully this presentation is going to allow you to expand your understanding of how 1031s can be used in connection with the acquisition of a larger asset like an apartment building.
Dugan, will you be discussing what like-kind means?
Yeah, so yes, we will. But like kind essentially means any type of commercial real property. It has to be real property. It cannot be stocks, bonds. That's why as we get further into the presentation, you'll see that the structure, the actual deal structure needs to change because the IRS says, we're going to give you tax deferral, but only if you reinvest those sale proceeds into a like-kind property. So it doesn't have to be the same exact property. So if you sold a rental single-family residential home, you don't have to then reinvest into another single-family residential home that you've been renting out to commercial tenants or to other tenants. But you could go from single-family residential to apartment building, single family residential to vacant land, single family residential to, any type of real estate asset, but it has to be real property. Here are the easy rules. Okay. So you can certainly read in the tax code, but the easy rules are all cash proceeds from the sale of the relinquished property must be reinvested in the replacement property, or guess what? You're going to pay the tax on that difference. So that doesn't mean that you absolutely have to take 100% of the sale proceeds and reinvest them into another property. You can choose to take some of that out and pay the tax on it. But if you take some of that cash out, you're going to pay the tax on the difference. The purchase price of the replacement property, remember this is the second property, must be at least as much as the sales price of the relinquished property, or guess what? You're going to pay the tax. The purchaser of the replacement property must be the same as the seller of the relinquished property, or be a disregarded entity. This is key. Okay, this is very important because I can't tell you how many calls and that I have, probably Mark, you have the same, Brent, you may have the same, with people that say, I sold, it's husband and wife or male or female, sold a property, but they have an LLC that they want to create, or they want to own their ownership through an LLC or an entity. That is treated as a disregarded entity. So the IRS is ultimately looking at who is the taxpayer. So if you own the property individually through your Social Security number, then guess what? Your Social Security number needs to be the owner of the next property. But LLCs are treated as disregarded entities. So you can sell a property individually and own it through an LLC, or sell a property through that LLC and then acquire your ownership in the next property through that same LLC. And then the last easy rule is for safe harbor protection. What do we mean by safe harbor protection? Meaning I'm not going to have to pay taxes. I am protected. There's a safe harbor provision there. I don't have to pay taxes on those. Exchange funds must be held by what we call a qualified intermediary. That is simply a person, or more likely an entity, a business out there, that this is what they do. They are a qualified intermediary. They hold in escrow the funds from the sale of your property to essentially deploy those. And the reason why that is you're not touching that money. If you touch that money, guess what? You're going to have to pay the tax on it, because the IRS says you've actually received that money. And so that's why we use a qualified intermediary for 1031 exchanges. What's the timeline?
What they typically charge, Dugan? What a QI would
Yeah,
charge?
so the typical charges are very manageable. So a typical exchange, a qualified intermediary exchange will typically charge somewhere between $500 to $1,000 for the actual exchange. Maybe a little bit more, sometimes a little bit less, but somewhere in that thing. So we're not talking about thousands of dollars for them to be basically providing escrow services, the intermediary services, and then they will also help facilitate the purchase of that next acquisition, meaning they will wire in your sale proceeds into the next title company, the title company that's handling the acquisition. So that's generally speaking the type of services that they will provide. And they'll also, a good qualified intermediary will also interface with your lawyers or your CPA for your tax filings. They will help you in that. When we're talking about a timeline here, this is the basic timeline that everybody that's using a 1031 needs to have in mind, right? So day one is I sell the property. That starts the clock, folks. That starts the clock. I have 45 days. These are rigid rules. Remember, we're dealing with a crotchety Uncle Sam. They will not bend these rules for you. They will not bend them for me. They will not even bend them for Mark, right? These are rigid rules. You've got 45 days to identify those replacement properties. And then after that 45-day identification, meaning we are identifying to the IRS and to our qualified intermediary, here are the 3 properties that I've identified. Not that I'm going to acquire all 3 properties, but if I don't list the potential apartment building that I may acquire an interest in, then guess what? You're out of luck. It will not qualify for 1031. So that 45-day period is very key to identify that. And then I have to close within 180 days from day 1 to 180. So deadline to identify, 45 days. Deadline to purchase the replacement property or properties needs to be done within that 180-day time frame.
And I would say, just recommend people identify, the 3 properties. Don't just think you have one property and you're going to come into a syndication. What if that one property doesn't close? Now you're stuck. So identify the 3 properties. You can invest in the 3 properties too if you want to split it up. Another question, Dugan, what if someone had multiple properties they're selling? When they sell today, when they sell 2 weeks from now, can they accumulate those properties together and then come into a 1031 exchange combined together?
They can. Yes, they can. That's fair. That happens often by the QI, and you should use the same QI. So can't stress that enough. If you think about you're going to put one of your commercial properties up for sale, and that you think that or you contemplate using the 1031 process, start those conversations now to put in place your relationship with a qualified intermediary. So when you sell the property, that your title company can almost immediately deploy that capital into the QI's escrow account. You don't want to be scrambling around trying to find that out, which delays the closing. So remember, you cannot take possession of those sale proceeds. You need to have that qualified intermediary already lined up. This is a typical deal structure. So seasoned multifamily investors will recognize this. Those of you that are watching this presentation that are just interested in the 1031 process, this may be new for you. In this hypothetical, we're acquiring an apartment building. We have a 70%, 30% split, meaning we're selling off part of the entity that will ultimately own the apartment building. We're selling off 70% of that to passive investors. And the sponsors of the deal are retaining 30%. In this hypothetical, we have 2 entities that are sponsoring this acquisition, Best Gals LLC and Best Guys LLC. And they're 50-50. So we have 2 sponsors, they're 50-50. They're going to split that 30%. This is a 70-30 split. And they're also going to be the asset manager of that apartment building. It's not uncommon. In fact, it's probably par for the course that the sponsors are also what we consider the asset managers for the passive investors in the typical deal structure. Why would a sponsor, so why would a seasoned operator sponsor of multifamily properties, why would they even consider a 1031 exchange? Well, I've said for years, the most difficult thing for every sponsor is to raise capital, right? It's a challenge and it's an awesome responsibility to be entrusted to try to raise capital in order to acquire the debt. So often at the same time that we are raising capital in the syndication, we're also contemporaneously raising debt, meaning we're raising, just like the purchase of your single family residential home, you had to show up at closing and give them 3% of the purchase price, 5% of the purchase price, whatever that equity is that the bank said, you got to show up and give that to us. So think about from an apartment building, that scale, that amount just gets much larger. So And often the sponsors do not have the ability, they don't have millions of dollars laying around for the equity for the 20%. If you have 80% leverage, and if you have a bank that's willing to give you 80% loan, you don't have the 20%. So we syndicate that equity, meaning we're pooling together private investors' money in order to obtain that loan. So we're raising debt and we're raising equity at the same time. That is a very significant challenge that everyone that sponsors and syndicates has to deal with. So obviously, this helps when you have a 1031 party that has to deploy that capital. Remember that 180-day time frame, and even more, that 45-day time frame. They have to identify properties that they're going to reinvest that capital into, or they're going to pay the tax. So they have added additional pressure on them than the private investor, than the private retail investor. The private retail investor doesn't have to invest in the syndication if they don't want to. But the 1031 party has to deploy that capital, or they have to pay the tax. So from the sponsor side, you should welcome and love talking to potential co-owners of the property that have 1031 money, because this helps potentially shrink the amount that you have to come to the table to the banker to give in order to acquire the loan. And in some cases, it only takes one. So as a sponsor or syndicator, you may have a large 1031 party, somebody that theoretically has millions of dollars that they need to deploy. And in other words, it only takes one co-owner to essentially hit that equity threshold that the bank is looking for. And therefore, you don't have to go out and raise from a bunch of private retail investors.
And we've done that before. Yeah, we've done that before.
So here's a question, and this might be more for Mark. When you're bringing a 1031 investor, is there a certain amount of capital where it might make sense or worthwhile to bring them in?
I was actually just going to mention that everyone has to kind of decide what makes sense. There is more involved bringing a 1031. We've done it, I think, 5 times now, 4 or 5 times, I guess. There's more work involved in doing that. So if someone comes to you, let's say you're raising, a few $1 million, and someone says, "Hey, I'm selling a single family house I have, and here's $75,000 or $100,000 or whatever. Can I do a 1031 into your syndication?" Each syndicator has to decide what their threshold is. I personally wouldn't do it for $75,000 or $100,000 because there is more work involved. They also, the 1031, and Dugan, correct me here, 1031 person putting equity in also will sign the loan.
That's right.
So you have somebody else now signing the loan alongside you, so there's potentially risk involved there. Even though the loans are non-recourse, there's still potential risk, right? If something happens, it can become recourse. So each person should decide. I don't know. I know Dugan and I know someone that says they won't bring anyone in for less than $8 million. 1031, that's quite high in my opinion. The one we did was a $5 million that one single person came in and did the entire deal, but we've done it for much less than that too. So typically for us, and it could vary from time to time, we usually look for 500,000 or more. That's just our threshold for a 1031 person to bring funds. And I will make a comment along funds because for some reason there's misconception out there of people that are providing 1031 funds. They'll say, "I have $1 million equity I'm going to bring to the table." We had this example. Dugan and I did. The guy said he had 1.3 million. He's bringing in. We're like, "Great. Here's the deal." And he identified the deal, and we'll come to find out he had $330,000, not 1.3. He was including his debt.
Ooh.
All right. As a syndicator, that is completely 100% irrelevant to me. And you need to ask the question, okay, you have this much money. How much money are you actually investing in the deal? And ask them if they have debt and get those numbers. If they say, "I'm investing $1 million," and my debt is, 2 million and whatever. Okay, that makes sense. If they say I'm investing $1 million, my debt's $1 million, then there's probably a problem there, right? The numbers have to add up. So be very careful and make sure it's very clear to you, the syndicator, what the 1031 exchange individual or the individuals are doing, are bringing to the table in cash to your deal.
That's right. Yeah. So almost universally, sponsors of multifamily acquisitions are going to be calculating the undivided interest of ownership in the real property that the 1031 parties will own, will be on the basis of actual cash that they're bringing to the table. So remember, the sponsors in the syndicated entity, they're bringing cash. They're bringing generally speaking, the lion's share of the cash to the table, and they will own proportionately an undivided interest that is calculated back to the amount of cash that they bring to the table. The 1031 party on the other side will also hopefully bring some cash. The debt side that Mark said, well, you're always going to be, I shouldn't say always, you will most always qualify for the debt because the sponsors who are signing on the loan, the 1031 party, the bank, the lender will also require them to sign on the loan. And what is so appealing for most 1031 parties is, think about this. If you're selling let's say you have a dry cleaners, right? So you have a loan on that dry cleaners and you've made a little bit of money on the sale of that, and you want a 1031. Well, the loan on the multifamily is generally speaking non-recourse. So you're going from a recourse loan on a dry cleaners business to theoretically a non-recourse loan in which you're essentially leveraging up. So the potentially the cash flow that you'll receive from the multifamily property, your ownership in that is greater than that you're receiving in the dry cleaners, and your appreciation, your overall appreciation in your undivided ownership in the multifamily property is likely greater than what you had in the dry cleaners as well. That's why, and it's non-recourse, meaning you've limited the potential exposure that you as the 1031 party have in the marketplace. All of these factors are why multifamily, which is generally speaking one of the only asset classifications in the country that still has non-recourse debt attached to it, is why multifamily properties are so appealing to the 1031 parties. Here are some important considerations for the sponsors. How much money is coming in? Just like Mark said, from a seasoned operator, he's often going to say, "Okay, great. You told me you had $1 million. Is that $1 million cash that's going to be reinvested, or is that $700,000 of debt and $300,000 of cash?"
We've got burned on this, so it's very important to ask that question. Believe me,
it's very, very important. If you don't ask that question, you could show up at the closing table where Mr. Banker or Mrs. Banker says, "Hey, Mark, where's the money?" And you're going to be looking over to your 1031 party, and they're going to say, "Well, I told you I had $1 million. You didn't ask me what amount of the $1 million was actually debt brought to the table." So it's very important for you as the operator, syndicator, to know what that is. Timing, right? So remember, we have that 180-day time frame. Not only do we have a 180-day time frame, the syndicator also has the pressure of the time frame imposed upon them in the purchase sale agreement, the PSA, which will often, you need to align those. So if the 1031 party calls up Mark and says, "Hey, Mark, I'm going to have about $1 million to invest," but they haven't yet sold the property, and Mark needs to close on the acquisition in 30 days, that transaction is probably not going to happen because those dates are not aligned, right? So you need to be aware of those and be speaking with, or your lawyer has to be communicating with the qualified intermediary in order to line up those dates. And then expectations. So remember, the sponsor and the 1031 party, the 1031 people are not investors. Let me say that again. They are not investors in your syndicated entity. They are investors in the real property. They will own an undivided interest in the real property of some percentage along with you as the sponsor / asset manager of the syndicated entity. So it could be a 90% syndicated entity owns 90% undivided interest in the real property, and the 1031 investor owns 10% undivided interest in the real property. But they do not own 10% in the syndicated entity. So you need to be aligned in terms of money. When are distributions going to happen? What are the projected returns that are going to be generated from the rents and the revenue that comes out from the property? Who's going to control the day-to-day asset management of the property? Who's going to be interfacing with the vendors, the PM? If this is an added value project, right? There's going to be some amount of construction management, those types of things. Who's going to communicate? In large part, most 1031 parties that participate, they don't want to be that person, right? Remember, they may have little asset management experience in connection with managing a multifamily property, construction rehab, PM, interfacing with the lender. And the lender is going to be looking in general, even though all the co-owners, including the 1031 parties, will be signing on the debt. They will largely only want to talk to one or two people. They're not going to want to talk to, 5, 6, 7 people to figure out essentially what the consensus is. They're going to expect you as the sponsor / syndicator, the person that initially brought the lender the deal, to be essentially the point person between all of the co-owners. That's just practically speaking. But remember, all co-owners own an undivided interest in the real property. And what's the exit strategy, right? So if the 1031 party is looking at this as theoretically, I'm going to invest in this apartment building and I'm going to keep this for my life. And I want to keep it for my children's life. And we want to live off the cash flow forever generated from this apartment building. That may not work for the sponsor / syndicator, because if they're raising private equity, their investors, the passive investors, are going to be like, hey, Mark, what's our exit strategy? The market looks pretty hot right now. Let's sell so I can recoup and get a significant return on my investment. So you got to have those conversations with your 1031 party. Don't avoid uncomfortable conversations with them just because it's uncomfortable, right? Don't just assume that they're aligned with you in terms of control, money, and exit. You need to have those conversations with all of the co-owners. So what does this do to our structure, right? You may have heard this idea of a tick. Well, we're not talking about something that burrows into your skin, right? You have to pluck out. This is a tenant in common, AKA the acronym is TIC. Tenants in common is basically an ownership in which 2 or more people or entities, right? We have a syndicated entity. Maybe with the 1031 party has an entity. So we have 2 entities, theoretically. They will own shares, separate, undivided interests of the same real property. So each owner, each person, each entity holds an individual, undivided ownership interest in the real property. That's important. It's very important because it has to be that way in order for the 1031 party to be able to defer that tax. So our structure will change. So as the sponsor that's looking at this saying, hey, Dugan, this sounds great. I'm going to start listening more to people that might have 1031 money that they need to deploy. And you think to yourself, I'm just going to fold them in with all the other passive investors. No, you're not. You're not. They're not an investor. Remember, they're not an investor. They will own an undivided interest in the real property. This is an actual deal. The names have been removed, obviously, to protect privacy, but this is a chart from an actual deal that took place. So remember, our prior hypothetical was a 70-30 split, right? Where we had 2 sponsors, Best Gals and Best Guys, LLC. They were 50-50. Well, in this in this particular thing, best gals or best guys had two 1031 parties that contacted them and said, hey, I would like to participate. And here's the money, the actual cash that I have, not just debt. This is actual cash that I intend to reinvest and own a piece of the apartment building. Are you interested in being a co-owner with me? And they said, and the sponsor said, yes, I am interested. And so based on the amount of cash that the tenant in common brought to the table, we have Jane Doe and John Doe. So these are two individuals that brought money to the table to invest and own an undivided interest. Based on the actual cash they brought, Jane Doe had a 7.17% interest, undivided interest in the real property, and John Doe had a 4.56% interest in the real property. So you'll see the orange box, the sponsor and the syndicated entity's undivided interest in the real property shrunk from 100% to now it's 88.27%. Why? Because it has to account for the fact that now we have co-owners in the real property. It's not just owned 100% by the syndicated entity any longer. It's now owned by three parties. We have Jane Doe, John Doe, and Newco. So Best Gals and Best Guys created Newco, which was the entity that got syndicated. And the asset managers for this, all three owners said, well, the Jane Doe and John Doe said, well, I don't know anything about asset managing an apartment building or talking to the lender or managing the property management company or rehab or what's all that to do. We want you, Best Gals and Best Guys, to actually do that for us, okay? And so that structure, this is a typical structure, a typical tick structure for you as the sponsor and for what you should expect as the 1031 party that comes into this. What are immediate action items? If you have somebody, if you're a sponsor of a deal and you have somebody that says, hey, I have 1031 money that has to be deployed. I want to come in, and you said, okay, great. Well, one, remember, who has the most skin in the game? It's not you as the syndicated entity, and it's not the 1031 party. It's the bank. Remember, we're raising our leverage in our scenario is 80%. We got 80% leverage, which means that we have to come to the closing table with 20% of the cash in order to acquire the loan. So we got to notify our lender immediately. Our lender may have specific underwriting rules that deals with 1031 parties, okay? We need to notify the qualified intermediary. Hello, my name is Mark, and I've got an apartment building, and this is when I'm closing. What's the status with your time frame? We need to start working on the required diligence items. The diligence items are not necessarily property related. These are business diligence items related to the 1031 parties being underwritten by the lender. Because remember, everyone that is a co-owner on a piece of property, regardless of their percentage, will often be underwritten by the lender. So let me say this again. The lender will require John Doe and Jane Doe, even though their percentage of ownership, it may be even less than one of your passive investors, because they are recognized as a co-owner on the actual real property versus your passive investor that may have a greater percentage of ownership in the real property. They own their ownership in the real property is through the syndicated entity. The syndicated entity and the sponsors are being underwritten, but not necessarily every passive investor. So, but every 1031 party that gets into a property will be underwritten, and there will be a list of diligence items. So if you're using a mortgage broker, often your mortgage broker will help facilitate those items. The sponsor will also have to take the lead. Let me say that again. The sponsor, like Mark said, this requires more effort on behalf of the sponsor. The sponsors will likely often have to take the lead in pulling, pushing, prodding, kicking, screaming, making sure that all of the diligence items from all of the co-owners, including the TIC parties, actually get to the lender. You need to inform your investors. So if you launched a private offering to your investors and you did not inform them that you would be listening to and potentially entering into a deal with 1031 parties, you need to inform them of that fact, because it may change what type of distributions they will actually receive, or what the overall ownership of the asset, the apartment building, actually is, depending on how the deal is structured with the 1031 parties. And then you got to make sure that your pro forma works, right? So if you're taking in 1031 parties, you're also the sponsor syndicator. Remember, you have fiduciary obligations to your investors to try to make sure that your pro forma still works, depending on what your deal structure looks like.
So Dugan, a quick comment, I guess, on informing the investors could be if you know you're bringing a 1031 person in from the start, your PPM, company agreement, things like that can already account for that. If you don't, and you've already sent out all your investor docs, then you could communicate it through an amendment to the PPM, correct?
That's right. Yeah, don't do it in secret. So if the material terms change, you need to kick out a supplement to your investors. You need to inform of the fact. You need to allow them the opportunity to ask the sponsors any questions that they might have vis-a-vis what happens now that there's a 1031 party in there. You just need to be transparent, authentic in your communications. Don't just assume that your investors will accept essentially your decision. You may have investors that say, I don't want that. I don't like that. And as a result, you need to find a way to potentially either make them happy or get them out of the deal. If as the sponsor, that's your obligation to essentially inform them, answer their questions, satisfy any concerns that they might have. If you can't satisfy their concerns, my rule of thumb is try to buy them out, take them out of the equation, or refund their money if the offering hasn't closed, meaning their money isn't hard yet. You haven't broken impounds. Refund their money. It's not even if you legally can keep their money or hold on to their money, it's not a wise policy. That's not a good thing for you as the sponsor syndicator in the deal.
Just a quick comment on the pro forma piece. From a legal standpoint, Dugan's talking about is different, more documents, a different structure, things like that. But from a overall perspective, you can treat your 1031 partner, if you want to say, from a financial standpoint, just like you do any other limited partner. You can pay them pref if you want to. You can choose not to pay them pref. You can do different things. So in some cases, your pro forma could look exactly the same with no change whatsoever, even though you brought a 1031 person in. Or you could decide to structure their piece of the equation differently, and then your pro forma could look different.
Yeah, it's really up to the individual negotiations that take place between yourself and the individual co-owners, the people that are coming into it as a TIC, right? So the key is to have those conversations with them to figure out essentially what the expectations are and be aligned, right? Because they're not passive investors. They are not your partners. They are treated under the law as co-owners. They will own an undivided interest in the real property. They're not your partners and they're not your investors. So with that, almost universally, a lender will require you to have a co-ownership agreement, right? So the lender, the one that has the most at risk, is not going to say, okay, let's just have some sort of loosey-goosey understanding of what's going to take place. No, they're going to want what essentially is an operating agreement that exists between all of the owners as to what's going to take place, the lender's rights, paying debt service first, what the distributions look like, what are the voting rights in connection with the property as a whole. So this is often called a TIC agreement or a co-ownership agreement, and this will need to be approved by your lender. In many instances, your lender may even give you a base document on which that's already been lender approved, upon which that you can add or modify certain terms. But ultimately, remember, the lender is the most exposed in this scenario because they have 80% of the actual cash used to buy the apartment building they have at risk. So you can imagine that the terms associated not only in the operating agreement for the syndicated entity, but the co-ownership agreement is signed off by and reviewed and analyzed and tore apart and changed by the lender in this scenario. Here are some of the key terms that you're going to expect to see in any co-ownership agreement, whether you're the sponsor or the 1031 party, is that you're not partners, you're co-owners, and that you must hold your interest as tenants in common. So can't stress that enough. You're not partners. Partner, unfortunately, is a dirty word when it comes to 1031s because we're talking about tax deferred definition of what a 1031 party is. The law allows up to 35 people that theoretically could be co-owners or tenants in common, right? You could have 35 TICs. The reality is that your lender is not going to give you 35, okay? Your lender may give you 5, maybe a little bit more than 5, depending on the size of the acquisition, but they're not going to give you 35. I haven't seen a lender yet in 20 years that has said, yeah, that's fine, 35. Let's go. Let's all get on the bus together. It's not going to happen. So that's why Mark said as a sponsor, that's why you'll see sponsors, syndicators, have a kind of an artificial litmus test of what they're looking for in a potential co-owner, potential TIC party on the amount of cash that they actually bring to the deal. It's not on a several $1 million, let's say it's a $10 million acquisition and you're raising $3 million. If 5 TIC party, 5 or 10 people come to you and say, hey, I have 1031 money. I have 25,000. I have 10,000. I have 5,000. I have 50,000. I have 100,000. Those sorts of numbers, Mark's probably going to be, man, I would love to continue that relationship with you. But this is probably not the most suitable acquisition for you to participate in. Why? Because he knows that the likelihood is that the lender is going to say, no mas, we're not allowing this to take place. Not going to happen because there's too many TICs and their skin in the game is too small. Practically speaking, it's just not going to work, right? So you need to make sure also that your TIC agreement, remember a co-ownership agreement, aligns with the new co-operating agreement. Meaning if your exit strategy is 5 or 6 years, then you need to get aligned with the co-owners to figure out if their exit strategy also aligns with that. And it actually states what the actual ownership interests are stated, meaning this is not a moving kind of target. Once their interests are solidified, they will go on the deed. Their ownership interest, let me say that again, the actual TIC owners will actually go on the deed. So if somebody that has nothing to do with the deal at all goes down to the county courthouse and gets a copy of the deed and they see that syndicated entity, right? Best gals, best guys is on the deed, but they'll also see John Doe at 4 point whatever percent was in our hypothetical, and Jane Doe at 7% hypothetical. And that the new co will be at 88% and change. They will see all of that. So it's a fixed interest. It's not like, hey, you didn't show up to the last kind of co-owners meeting, so therefore we get to reduce your overall percentage. And it doesn't work that way. Control, right? The lender is often going to want to centralize control, asset management of the actual apartment building, right? Because they have 80% of their money at risk. So they're not going to want to have a lot of cooks in the kitchen. So their co-ownership agreement, the lender may impose upon you one asset manager. In our hypothetical, the lender imposed best gals, best guys who happen to be also the sponsors of the deal and the managers of the syndicated entity as the asset managers. The lender will often restrict your ability to transfer, sell, or incur debt, additional debt in connection with the TIC's interest. So distributions, when, how, and in what amount. You're going to want to have that. The debts, when, how, and what amount, right? Voting rights, and this is generally not, remember, they don't have voting rights in connection with the syndicated entity, and you don't have voting rights in connection with their entity. But globally, you all may have voting rights or figuring out exactly how you're going to run the apartment building. And then what happens if we get into a fight with one another or a dispute? What type of dispute resolution do you have specified in your co-ownership agreement? And then lastly, but most importantly, what's the exit strategy? So those are often key terms that you're going to see in any type of co-ownership agreement that are also going to be signed off by and approved by the lender. The lender will enforce its rights on the TIC parties, okay? Let me say that again. The lender will enforce its rights, right? They're not going to allow you to invest into an apartment building without signing on the loan. They're not going to allow you to go on deed without incurring some of the obligations, meaning you're going to the extent that the loan is also non-recourse, you as the TIC party are going to be signing that loan. And the carve-outs, you may be guaranteeing that loan. So if it's a non-recourse loan with guarantees, you're going to be signing one of those guarantees. The co-ownership agreement will not have any conflicts with the loan docs. Remember, the loan docs are obviously, they're supreme, right? Because the lender has 80% of the money tied up in this deal. And they're also may restrict your right to partition, meaning sell, transfer while the loan is present. Without you fully satisfying the debt, they're not going to just allow you to willy-nilly go out and give away part of their collateral to somebody else. Even if you only own, like Jane Doe or John Doe, 4% or 7%, they're going to restrict your ability to do that until the debt is fully satisfied. All right, so here are the recaps. So I know that was a long snooze fest for many of you, but this is the recaps.
Yeah, I dozed off a couple of times, Dugan.
I'm wide awake, Dugan. This is riveting.
This is riveting. This is riveting. Hey, it's exciting for sponsors to remember that this is a diversified capital stream, potential diversified capital stream for you.
Yeah, dude, that's an example that you know, right? I mean, we had a guy bring $5 million to the table. This particular 1031 co-owner also brought all their earnest money, 100% of himself. So that was a very good deal for us. So it's definitely eye-opening for sure. Just make sure you're educated about it. Make sure you engage someone like Dugan, involved in anything along these lines, and make sure you're following the legal pieces of it.
Right. So that's it. That's kind of the recap here for this is kind of the pathway. The 1031, they benefit both the syndicators and the passive investors. It provides you an opportunity to deploy your capital in which you often, as a 1031 party, are limiting your risk, increasing your potential cash flow, increasing your appreciation, and you're limiting your downside. So the question is, why would you not seriously, as a 1031 party, seriously think about approaching syndicators or operators about the possibility of the need for you to deploy your capital? And as a syndicator, why would you not seriously think about talking to potential parties that are 1031 that need to deploy that capital, because it helps you with the most critical and often most difficult component of your task, and that is the entire sponsorship team of raising that equity necessary to acquire the loan. Remember, you got to determine what is the 1031 party actually bringing to the table. Have those uncomfortable conversations. Notify all your parties, the lender, the QI, your investors. Your structure will change. There's no ifs, ands, or buts about it. A TIC structure is different than a single syndicated entity. There will be a need for a TIC agreement, co-ownership agreement. You got to sign that TIC agreement, the loan docs and all the transfer docs, and then you close on the acquisition. So that's kind of the pathway for 1031 parties. Any questions?
I have a question, Dugan, not necessarily what you went over, but it's related to 1031. A lot of people are already in deals, right? So let's say you have a deal from 2 years ago, 20 investors in it, and someone approaches a syndicator and says, hey, why don't we 1031 out of this deal? So it was never structured as a 1031 or a TIC or anything like that up front. Any comments on that?
Yeah, I think the reason why most syndications do not 1031 into the next deal is because it's often the mindset of the sponsor is, how am I going to get all of my investors to agree? So if it's a large syndication and I've got, let's say, 100 investors, I mean, that's 100 conversations theoretically with each individual investor to figure out whether they're willing to 1031. There's no prohibition on the syndicated entity. The syndicated entity, for taxation purposes, is treated as essentially a taxpayer. So that same taxpayer, that NewCo LLC, could sell the apartment building and then 1031 into a larger apartment building. There's no issues with that. The issues become, what are the expectations of all of your passive investors as to whether they are willing to go on that second ride with you. So remember, they agreed to go on the first ride. If that first ride is a little bumpy, they're likely not going to pay the tab to go on that second ride. They're going to bail off the roller coaster. But if it was a smooth ride and they have no expectations or need for the gain, then theoretically you can do that. You're going to need to have those conversations with your investors. Many sponsors or syndicators that want to 1031 will employ what we call theoretically a drop and swap, which is prior to the sale or closing with the lender's permission. Theoretically, they'll lump some investors into one category of people that are going to need, that they want their cash and they want to get out and they're willing to pay the taxes. And the other side will continue to go on and leverage up through a 1031. That's called a drop and swap, meaning part of the NewCo dropped their interest and swapped it into a new entity that will be essentially a TIC or a tenant in common. And on the sale, that particular tenant in common takes the proceeds, pays the taxes, and does whatever they want. The other tenant in common is wholly independent. Their interests for the future doesn't have to be aligned, and they can 1031 into the next acquisition. The key, as Mark has already identified, is what are your expectations as a passive investor, and as the sponsor, you need to manage those expectations. So a syndication with 10 investors, maybe 20 investors, is much more manageable, I think, than a syndication with several hundred, unless your operating agreement allows, essentially upon a vote over the objection of the passive investors, essentially we are going to 1031. So if we have a super majority vote of all of the members, including the passive investors and the active members, that we're going to 1031, and that's in your operating agreement, then over their objections, you're 1031ing. But remember, we want happy investors. So let's say you had 67% of your members voted to 1031 into the next property. What are you going to do with the 30+% that are not happy with that decision?
Or need the
You know?
money, right? I mean, it could just be they need the money for some sort of life event or things
Right.
like that. So
That's right. That's
yeah.
right. Absolutely. And there's
Dugan,
life
how can
events.
people get a hold of you?
Yeah, so people can get a hold of me at kellyclarklaw.com. That's our website. They can also email me at Dugan, Dugan, at kellyclark.com. Kelly is Kelley. Clark is Clarke.
Sweet. Really, really appreciate it. It's a something that we studied early on, right, with you. We're able to do it multiple times, so it definitely makes sense if you can structure it in the right way and make sense for everybody. But it's helped us tremendously on the syndication side, and really appreciate your help on that, Dugan. And we'll talk soon.
All right, everybody. Thanks.
Take
Thanks,
care.
Dugan.